Hello. We're talking today about a situation when you are called to be a witness, or you expect that you will be a witness, or you'll be a witness in your own case, for example, or you might need to have given a written testimony, or at least an affidavit, but about an affidavit we'll talk later. So, why it is important to know what is the role and what is expected from you as a witness, and why it is really, really, really important to prepare. Many cases fall apart because the witness was not prepared, because the witness was talking whatever, saying what the witness thought, what was at the moment true, but then changed his or her mind, but then realized that he or she does not remember properly. And I'm not talking about criminal cases. I'm talking about civil cases, which are very often, more often than not, are based on facts that can or cannot be proved. And if the only thing if you don't have documents, basically, or your documents are not presenting some conclusive evidence, and you need testimonies, neighbors, relatives, colleagues, partners, and their testimonies are not well prepared, then the judge, even if the judge would be there trying to help you, but without some real evidence, the judge could not do anything about it. So it's important to have prepared yourself as a witness, or if you're expecting somebody to be a witness, to prepare that person. What is important to take into consideration? First of all, there are two kinds of witnesses: regular witnesses and expert witnesses, and we are talking mostly about regular ones here, because the Code of Civil Procedure has specific rule about experts and what they can and what they cannot do, and when they're called in person. But mostly, uh, for their testimony, what they have is their, at least in Quebec, is their written report, and that written report is something uh, that is usually presented to the judge and sometimes discussed, and sometimes there is an examination of that, but it's not the situation for a regular witness. When it comes to a regular witness, many people think that they come to testify in support of their friend, their relative, some person they know. So that's the thing they try to express, their support. And sometimes they try to paint with black paint like the other party. But that's not what the judge is interested in. So at best, the judge will just skip that part. At worst, the judge would think that the witness has nothing to say on the point, some has nothing to say of value. So the whole testimony being disorganized and emotional and full of some assessments and some labels put on some people, it can be all like just thrown away. Because what's expected from the witness is the first-hand knowledge, like facts basically. I saw this, I heard this. Well, I felt this if something came to that part. Uh, so I saw a person in a dark room or wherever going from there to there, from that to that direction or something like that. And maybe I called, maybe I heard something, and so forth. It's important that the judge is interested in facts, not in conclusions. So if you say, I saw him or her doing this and that, uh, it's important to make it sure that it's not your guess that it was him or her, that you either you're like absolutely saw that person, or if you reasoned in your head that was that person, then you should present to the judge the way of your reasoning. So I saw this, this, and this. Usually he wears that coat. Usually he smokes that pipe and so forth. And therefore I thought it was him or her, for example. Or it's not that he wrote, because I didn't see how he or she wrote something, but I saw a handwriting. And the handwriting I recognized as his or hers, therefore I thought that he or she wrote it. Basically, the idea is that the conclusions belong to the judge. You have to present only facts. The judge will make the conclusions from those facts. And even if you wish to impose some conclusions on the judge, but the judge normally would understand that from the facts as you present them, maybe this is the only possible conclusion, maybe it's the most plausible conclusion, maybe it's only one of the plausible conclusions. But if you only present the conclusion and no facts which led you to that conclusion, then for the judge it's empty. It's just you said so, but what did you see? What did you hear? Speaking of what you did hear, probably you heard about hearsay or oui dire in French, meaning that you should not convey the words of some other, like some other persons. Some people were present and you were not. There is a point. So you can present as a fact that you heard something. So you heard your neighbor saying that he saw that lady, but that won't prove that he actually saw that lady or that that lady was actually there. It will only prove that your neighbor said those words, and you heard them with your own ears. So to that effect, it was your first-hand knowledge, but it will not prove anything beyond that. So if you did not see something, if you did not hear something on your own, if you only trusted somebody else, then you should not present it as a fact, and technically that other person should be called as a witness, basically. There is a big, huge mistake or a serious way to spoil your testimony. When you appear partial, when you clearly want to convince the judge about something, when you clearly want to argue the case instead of conveying facts, the more you look like trying to convince and argue, the less probative value, the less is the value of your testimony. So you have, if you want to be credible, you have to stick to the facts. And speaking of facts, you have to stick to the facts that are relevant to the case. For example, in estate matters, succession matters, family matters, there are a lot of situations when family members, friends go like way back to the childhood or the decades ago, remembering something and something and something that has nothing to do with the case, but just paints the person in a certain way. Or because for those who are testifying, it's the whole big story, and they think that there is a connection. They go all the way back there, but the connection is not evident to the judge. So for the judge, it's just some blah blah, which again diminishes the credibility of what you are saying. Another thing, some people think that if you already said something during your testimony, and then later you realized that it was wrong, but you should stick to the first word because otherwise it would be perjury. The common approach, legal judicial approach, is that as long as you voluntarily came back and corrected yourself during the same hearing, or better even during the same testimony, then you're okay, because you did not want to lie to the court. It was an honest mistake. You honestly corrected it the moment you just thought of it. So insisting on your mistake when you already know that it's a mistake, that would make a perjury. It's better to correct yourself. And continuing with that, very often many people think that they have good memory and that they do not need any preparation. And then they present something incoherent, jumping from one and another, correcting themselves all the time. And at the end, it's a mess, and the judge simply dismisses it all. Uh, do not trust your memory. Do not trust your logic, your coherence. Think of it. Make a plan of your testimony. Rehearse. Verify that what you're saying is actually true, at least to the best of your memory. And once after fourth, fifth repetition, think of it as a sort of a presentation, even though you will be answering questions, but still. As long as you know the whole story, of course, you should not lie. You should tell the story as you know it, but it's still better to present it as you know it than to present only some just pieces of it which have no connection and makes a very bad impression. If you can, rehearse it with your lawyer who will be asking questions. If not, at least among yourselves. And do remember that however much you're sure that you're telling the truth, first of all, you might honestly have forgotten something. You must have misunderstood something in the beginning or misinterpreted. And the lawyer of the other party will be exploiting that part. So whenever you're saying something like with absolute faith in your words, like you believe every word, then you might find yourself really lost if during this cross-examination it would appear that you actually do not remember something or have forgotten something or misinterpreted or misunderstood or made a mistake. So allow yourself that you might be not exactly sure about every particular moment. And if you verified something after, remember to testify true to the fact that you verified something after. It's not what happened on the point. Because it's better to be corrected in some small detail than to insist and then appear before the judge as a lying person who, at best, does not remember at all and still tries to convince being clearly mistaken. So this is it. In short, the role of the witness is not to argue for some party, but only to present the facts as they were perceived firsthand, only those small facts, totally like leaving out of the picture everything that was heard about it, everything that was drawn your emotional reaction to it, and so forth. Conclusions are for the judge. It's the judge's job. Thank you and have a nice day.